Your case sounds complicated in theory, but actually in practice, it's not even supposed to be. Why? Because one, apart from the fact that you're having a child who is of German descent, and you're supposed to get the 28, which is a caregiver Aufenthalt, you've stayed so long in Germany. Like you've stayed so long in Germany, which means there are other conditions that you fulfill for other paragraphs, even if you're not getting the caregiver Aufenthalt. So that's the first thing. And then the second thing that I want to say is your case involves two lawyers, not one. So right now you're dealing with a family lawyer. You're not yet dealing with an immigration lawyer. So the first thing that you have to know is you have to deal one with a family lawyer that is fighting the custody for your child, for you. And then two, you are also having an immigration lawyer. The first thing that your immigration lawyer will be doing is putting out for what is called I-Antrag for you to block deportation. Because I don't even see why you're scared. So that's the first thing your lawyer is supposed, the immigration lawyer should be doing for you, putting for the Eiswilliger Rechtsschutz, I-Antrag in short, okay, to stop deportation. While your family lawyer, and both will be working hand in hand, while your family lawyer now is fighting the part of the child, why is it that your baby mama is refusing you from seeing the baby? Do you share equal custody with her? That's the first thing that is supposed to be known. If you share equal custody with her and she's still refusing you from getting contact with your child, then you have all the right to take her to court, to take her to Jugendamt. If you've gone to court before and she's still adamant to adhere to the court regulations, then you can now apply for penalties because she's not doing well, not to the baby. The baby has the right to build contact with you and her, not only with one parent. That's what is said under the family law. From the side of the Ausländer Behörde, normally their actions are a little bit legally questionable if you've provided every proof to show them your efforts that you've been making to build contact with your daughter. But on the other hand, if you want to look at it lawfully, they are right because that paragraph, that 28 that you are supposed to get because you're having a child of German descent, is a caretaker Aufenthalt. Caretaker Aufenthalt simply means that if you have a German child, you are getting the 28 because you're taking care. You're supposed to be taking care of a child, so family ties, okay? That's what the paragraph is saying. So if they're not giving it to you, it's because they are claiming on their own hand that there is no ties between you and the daughter, so there is no need for you continuing to stay here. And remember, the 25 that you were having before is a paragraph, and I always say this in most of my videos, it's a paragraph that when the conditions for which you had deportation ban, you had that document, that 25, no longer exists in your home country, the Ausländer Behörde have the right to ask you to leave Germany. So that's why right now, if you cannot get the 28 and the conditions for which you had deportation bans before you got this baby of yours no longer hold in your home country, then they have the right to ask you to leave Germany. But as I already said, there are other paragraphs that you could, if you are well integrated. For your so many years in Germany, I will want to assume you're already well integrated. So there are other paragraphs that you could qualify for. For example, the 25B, if you are well integrated. My take would be, as fast as possible, you are not only depending on the family lawyer is doing one thing, and you have to look for a migration lawyer, except your family lawyer is also a migration lawyer, then it means the lawyer already probably knows what to do.